Good afternoon, everybody. I hope everyone made it through the queues and up the escalators. Let me begin by wishing you a warm welcome and to tell you that I'm very happy that you're all here to participate in what I believe will be a lively discussion on a very important topic, which is the role of intellectual property rights in the upcoming Transatlantic Trade and Investment Partnership. For those of you who don't know me, I'm a member of the European Parliament from the Netherlands, representing a party called D66, D66. We're a member of the Alliance of Liberals and Democrats for Europe. And in the Parliament, I work on the Foreign Affairs Committee, dealing with the European neighborhood, human rights. I work on the International Trade Committee, where I'm the shadow rapporteur and spokesperson for the Liberals on TTIP, as the abbreviation is now called. And I work on Europe's digital agenda, intellectual property rights, access to culture, knowledge as well. So in that context, I thought it was a good opportunity to have an open discussion, access for anyone who wants to participate, about the role that intellectual property rights might play in the Transatlantic Trade and Investment Partnership. There's a lot of buzz in this city about the opportunities of the Trade and Investment Partnership with the United States, because it can bring economic growth, jobs, in a time of crisis without the need for government investment. And there's also a need to look at our competitive position in a rapidly changing world, not only in light of the crisis, but also in light of changing relations and emerging economies. The scope of the Transatlantic Trade and Investment Partnership will probably be very, very wide. We're now working on a resolution on the mandate, which the European Commission is asking from the member states, and we are giving our input as a parliament to be the negotiator on behalf of the European Union, and on the American side, that is the US trade representative. And in the wide scope of issues, one of the sensitive ones that has already sparked discussions and questions is that of intellectual property rights. And part of why there's a lot of concern about it is because not long ago in this parliament we had a very intense discussion about the anti-counterfeiting trade agreement, which was, contrary to TTIP, a more narrow scope proposed trade agreement, which I'm very happy we were able to vote off the table as a parliament, because there were a lot of risks involved for access to medicine, for digital freedoms, and the public support was frankly lacking for this trade agreement. Now, another lesson we learned from ACTA was that trade agreements that are not supported and created by the people and for the people are very difficult to find support for. So in the process of working on the Transatlantic Trade and Investment Partnership, it is my intention as shadow rapporteur to facilitate as much open discussion as possible, so that we as representatives here in the Parliament can best play our role in assessing the pros and cons of the Transatlantic Trade and Investment Partnership, and make sure that we're working on a deal that benefits Europeans in the best possible way. The reason why intellectual property rights are a sensitive issue is because, one, there's plenty of different ones. Some people only think about copyright when they hear IVIR, but of course there are other issues, such as the geographical indications that are important for a number of people here in the Parliament, and that many consider to be a major offensive interest of the EU vis-à-vis the United States in this issue. It's sensitive because of the question of how the enforcement of intellectual property rights in today's day and age that's highly digitized impacts individual liberties, people's digital freedoms, how they impact access to medicine, access to knowledge. And so a lot of questions are out there. Another question, of course, that runs throughout the Transatlantic Trade and Investment Partnership is how we're going to make our systems more compatible, more harmonized, while preserving values that we hold dear. And so to practically deal with different systems where fair use may be granted on the one hand, but not on the other side, what levels of protection we need are all questions that will no doubt come to the table. And of course, here in the EU, we've had a long and ongoing discussion about the need to reform intellectual property rights throughout the EU, to harmonize systems instead of dealing with the fragmentation. Now, the comparison between ACTA and TTIP has been made. The Commissioner has mentioned that he has heard the criticism against ACTA, that he has learned from the vote in the European Parliament, and that there will not be ACTA-like provisions in TTIP. So we're looking forward to hear more details from our first speaker. We have a very high-level panel, and I'm very happy that the four of you were willing and able to participate this afternoon. I also invited different representatives from the business community to talk about patents, but unfortunately none of the invited guests was in a position or ready to talk about the issue on the record at this stage, but I just wanted you to know that this was an invitation that was extended. But I believe we have a panel with various points of views to give introductions, and I very much look forward to a lively discussion with all of you. I hope that the introductions will be finished around 3 so that we have 1 hour for discussion, not only in this room, but also through our online participation. This meeting is live streamed. The hashtag for the meeting is IPRTTIP. Okay, once more, the hashtag is IPRTTIP. So feel free to tweet to engage with people that are not here today, and I will be looking at my laptop or my phone, not because I'm not listening to you, but to involve people from outside of this room in the meeting as well. So let me start by introducing the first speaker, Mr. Schlegelmilch, who is the Director of External Trade in DG Trade. He used to work at the Ministry of Foreign Affairs in Germany, also at the OECD, and was a WTO negotiator. So a long career in trade-related issues. We look forward to your thoughts from the European Commission side. Thank you very much.
Thank you, Marietje. And thanks for the introduction. Indeed, I'm looking after the services, investment, IP, and procurement part of this negotiation. And I'm very grateful. This is my first point to be able to talk about the issue here, because I'll say something about the ACTA experience at the end, but I think one thing I think we can all agree on in this context is transparency matters, and we have to get to the issues in real time in discussions with all stakeholders, the Parliament, and anyone who is interested. I also, I think, agree with the setting. This is not just any other free trade agreement. I think this is an important point we have to make up front to set the context correctly. This should be, at least in the minds of the policymakers, certainly in the Commission, this should be a real game changer, a comprehensive transatlantic partnership. Of course, its main content will be trade issues, but I think the spirit to approach it is not to have another mercantilistic discussion on 1 or 2 issues, but to have a real partnership which will secure, I think, the competitiveness of both our economies worldwide. I think this is an important opener, because otherwise we get lost in the trees before we even had a chance to define the forest. And here is where I think the IPR issues come in. The IPR issues, which you know are not really an issue of what we usually do in FTAs, which is to try to improve the situation in many of our partners in the protection of the various IP rights. I mean, it's no doubt, and I don't think anybody will question, that both in the EU and in the US, we have a very high standard of protection, including enforcement. We have very successful knowledge-based societies, which we want to preserve with the best possible environment. So there is nothing, I think, we want to do by way of trying to ratchet up, as we do in many of our FTAs, overall the level of protection. I think this is a very important point. And the second point is, while we do this, and if you look at some of the free trade agreements, either of the EU or the US, you will see that these rules that we have domestically or in the free trade agreements differ quite a lot. The effect is obviously the same, very much the same, high level of protection, But we use different approaches. We use basically what we know from home and try to have others as much as possible agree to this based on the TRIPS agreement and so on. But the consequence of this is that we're not going to waste time trying to harmonize this. We're not going to say, what we used in the Korea FTA, which is our most advanced ratified FTA, or what the US used in Chorus. Let's now try to find the golden middle ground and have a common standard for our IPR protection. That's not what we want to do. Our systems are basically not broken, so there is no reason to fix them via an external sort of impulse from an agreement. I think that's an important point. But that doesn't mean that we will not have an IP chapter. It will mean that we will be extremely pragmatic in how we're going to approach it. It means that we're going to look for issues which are out there where our stakeholders and meetings like this inform us that there is a real problem. If you look at the way the high-level working group which prepared the negotiation has phrased it, I think that gives you a good clue on how we want to approach it. In the high-level working group, we talk about looking for a limited number of significant IPR issues of interest to either side. Those should be addressed. It doesn't say we have a comprehensive chapter covering rules and establishing new rules on all the issues. And I think that is not pure harmonization, but it's really trying to find out what is it we can still do better. Where do companies and stakeholders tell us where there is scope to improve? Now, the demand of stakeholders, and we have done public consultations, already give us a few pointers, but that process is far from over. It's continuing in the EU, and I take the opportunity to announce that we are having a major stakeholder meeting on IPR on Friday in the framework of our DG Trade, what we call our DG Trade Civil Society Dialogue, where we want to collect further input on top of what we already heard in the public consultation, which we ran at the end of last year on this issue. So we're still doing this. One thing which is already clear to all of us, which will be a headache in the negotiation, but I think a positive headache, is that we want to improve the protection of geographical indications. This is the long-standing discussion. No surprise to the old hands in the trade discussions, where we would like to see a little bit more engagement from our US friends who are basically not very keen to work on that concept beyond what is in the WTO. That will be an interesting discussion, but I think that is a given that this has to be in this negotiation if it's comprehensive. But there are other issues out there which we're starting to crystallize, and I'll give you a few, not definitive ideas and hints, but I will give you a few pointers on what we think could be done. I mean, one area obviously where we will have to look at very hard is the whole question of the trademark and the patent system, especially upstream, before actually the decision is taken. I mean, the actual granting of the patent or the trademark, as I said, is deeply entrenched in the national or in the EU and US context, but there might be quite a lot of things we can do in how to get there. I mean, there are databases which are not necessarily open to the other side. There are processes which are duplicative, even if there are maybe somewhat different standards to work with. We have to look at that, especially for small and medium enterprises. This is still an issue that the systems, from the beginning, when you make your first application and you gather your facts and so on, the fact-finding part is different. Then we have an interesting debate on what we call trade secrets, which is a concept which is patchy, at least in the EU, and my colleagues from DG Markt are working on. It is a strong part of the US protection system, including things to ensure that products which violate trade secrets cannot necessarily enter in a certain stage the US market. It's a very complex issue, but there is a clear demand out there. We had a number of cases with a number of companies, European companies, American companies involved, where theft or what we call illegal appropriation of trade secrets was an issue. And we don't yet have a response, so we're looking into this. We're looking into this for our internal needs, but also as part of this discussion where there is, I think, demand, as I said, from the stakeholder side. There are some other issues which I will listen to you, which have been mentioned here and there, but let's see what the discussion here brings. One obvious other item, and this is my closing remark because ACTA has been mentioned, We are trying to look at the question of enforcement, but with a completely different angle. We're not going to have enforcement rules. ACTA was an attempt to sort of harmonize, and this is why it was unclear, as some of you have said, to harmonize the existing enforcement standards. That's not what's going to happen here. It's completely different. But we'll look at cooperation, whether we can be more effective in our individual attempts to have better enforcement. For example, I'll give you an example. Many of us, many countries, including the US and China and the EU, also Japan and others, have dialogues and have technical assistance for enforcement. That is the sort of thing where we might have more synergies and more information exchange. But I want to be crystal clear, we're not talking about sort of rules-based ideas on enforcement, which have been scary to some of you because of maybe slight differences between the national law. So that issue will come up because it isn't, I mean, we all agree, and everybody agreed in the ACTA debate, that counterfeiting is a problem. We didn't agree on the way to address it. Here we're talking about cooperation, which I think is a different thing than setting golden standards in an international binding agreement. This is a little bit what I want to say by way of opening. Again, stressing the message, we're still very open to look what these selected items should be. We are receiving, as we speak, we're receiving new submissions from stakeholders by the day, covering a wide range of issues. But again, we haven't taken a view on this. And my last point on this, neither has the US. If you look at the statements, the public statements available from our colleagues in USTR and elsewhere, they're doing exactly the same thing. They're consulting widely with their constituencies. And I think we will distill from that over time a somewhat more concrete agenda, including using the input that we get in meetings like today. Thank you.
Thank you very much. Just a practical question, this civil society dialogue, is this something we can announce here and everyone can participate next Friday? Where, when?
It's on our website. It's on Friday morning, I would think, on a Friday. I've just been told by one of your colleagues in full transparency that the registration process leaves somewhat to desired, but we'll look into that. We already have 50 or 60 participants registered. I don't know what's happening. But it's open to anyone who registered with DG Trade, which means basically everyone who takes 3 minutes.
Great. So, soon another opportunity for discussion. Great. Our next speaker will be Hosuk Makiyama, who is the Director of the European Center for International Political Economy, or ECIP, well-known think tank here in Brussels, which publishes several papers on trade issues, but also related to innovation and the digital economy. Look forward to hearing from you.
Thank you, Marietje Schaake. Well, now that we heard the Commission, I'm not sure how to follow up, but I'm actually paid to criticize the Commission on full time, but it's. I would like to put this in the context of free trade agreements. Before we start to talk about intellectual property, I would like to talk about the larger scope of why we need to do free trade agreements. Obviously, the need for growth and jobs and economic reforms in Europe, I think, is obvious to everyone. And the biggest and the most efficient source has always been externally looking outside. This is the pure logic of the European Union and the single market. And so the need for growth and need to create growth and the reason why we should look abroad is quite obvious, as the rest of the world, especially the emerging markets, are now taking a bigger considerable part of the global economy, but also because we are rapidly losing relevance as a trading power, as a norm setter. We are now currently accountable for 25% of the European GDP, the global GDP. This number will be halved by 2030, which means that our leverage as a export destination participant in the global economy will be halved very soon. So this is now the time to act, and this is now we can decide the framework, the rules of the global economic governance that we would like to see ahead. And so there are many misunderstandings about free trade agreement, and that one of them is that market access is the paramount. Basically, exporting our products abroad is the number one source of the efficiencies that FTAs bring. I would like to argue the opposite. Actually, as an economist, I tend to say that it's actually on the other side. It's on the import. You import efficiencies abroad that you don't have. If the counterpart is more efficient than you in research and development, then either you go and occupy the country and steal their factories, or you start trading with them. These are the options we have. And this explains the global fragmentation of the supply chains that we've seen, and also the increase in participation and the specialization that we've seen in the economy. And this is natural. There's nothing we can do to stop this. And actually, in fact, if we want to have an inclusive, more equitable society, we don't want to stop this. So far, we have concluded FTAs with 5% of the world GDP. And there are some very significant political gains that we have achieved in these FTAs that we've done so far. But there are 95% of the world we haven't done FTA with. And a significant share of that percentage are countries we probably can't do FTAs with for several reasons. But having said that, the biggest gains in the free trade is to be had on the import side, I would say that there are basically 3-4 economies that could have actually a tangible impact on the European economy, which are basically the economies that have more than $5 trillion in GDP per year. Otherwise, the countries are simply too small to matter. And these are basically in ranking order: China, United States, and Japan. And after that, basically, the scale drops. There are other reasons why we need to do these FTAs, and every single small stream counts, yes. But if you're looking to one single FTA to actually reform the economy, these are the ones that we need to do. And now, let's rapidly switch over to the IP side. I have talked about why the big FTAs matters for Europe. Basically, as the largest economy in the world, we need to do an FTA with the moon or another civilization in order to have a tangible effect. And this is no difference actually in terms of IP. But if I look back on what we have done and achieved and what our priorities have been in our external free trade agreements, they have primarily focused on geographic indications and copyright. And these are not necessarily the prime interest in terms of extending our market access or in terms of domestic reform. Let me explain. There are very little economic evidence that geographic indications is going to make or break for the European economy. In terms of, I have all the respect for GI producers. I myself, I don't buy products, well, I don't drink fake champagne, and that's not because I'm a snob, basically, because I prefer to get what I pay for. But simply put, the geographic indication in terms of, economic value added brings too little because the agricultural sector is too small. And to be frank, the counterfeiting, or let's say that the fake champagne, the consumer groups aren't significant enough to change the European economy. And we talk about copyright. It is actually an IP form which is pretty well protected in terms of length. We are talking about the protection length that exceeds 5-6 times more than the patent. And if you look at the manufacturing industry, and if you also look at the services industry, they're more fundamentally based around patent. If you look at FTAs as an economic instrument for economic policy, the priorities of Europe shows that they are not prioritized in accordance to, let's say, the interest of innovation, science, and market access, but rather from the point of view that we need to externalize some of our internal problems. For instance, the agriculture reform. They need to be paid off. They need to be traded off for something else, and other sectoral interest. So, having said that, what are we looking now when we see the big FTAs that we mentioned? EU-Japan is on the way, and so is TTIP. We need to bear in mind, and we need to be a little bit more sober about what free trade agreements can result in, because free trade agreements are not civil law acts. These are negotiation results, which is more or less binding, usually less. There is not a single country in the world, including the EU, who does not violate the WTO treaties. It's questionable, it's worth to take action upon them. So it's very important to bear in mind that free trade agreements should not be read as civil law. Second is that we haven't actually, so far, as EU, undertaken a single piece of reform due to the FTAs. We have transposed our legislation and our counterparts, but so far we haven't taken on a single piece of legislation from elsewhere. And to be frank, this is something that is due to our internal constitutional as well as policy-making structure that makes it extremely difficult to do so. And we need to also bear in mind that if you're talking about FTA between the big counterparts, we are pretty much looking like a Hollywood marriage. Two center of the universe who is going to share a bathroom doesn't necessarily make very good bedfellows. There are basically two entities, United States and the EU, had so far never ever had to undertake any single piece of reform in any of the previous FTAs. So the negotiation inclination of the trade negotiators, no offense, is basically geared, including the industry interest, towards a completely different opposite direction. Transpose your own legislation, someone else, don't reform yourself. And so this is really the reason why I'm inclined to say that in a Hollywood marriage, there won't be any positive rulemaking. The liberalization will be negative, which is basically the fundamental principle of the single market. If a product is, let's say, approved from the other side by the authorities and the government of the, let's say, the United States, we just need to take their word for it. It is safe for our countries. And this makes actually a very, let's say, contradictory template to the intellectual property reform, basically because you can't have negative liberalization on IP. So this is why I would say that the prospect of seeing something that will actually fundamentally change the way we see how we see intellectual property and how we apply it is very unlikely that there will be some kind of subject to change. And we need also finally, as a point, to say that this doesn't necessarily entail that FTAs are worthless. There are other chapters of course, of clear significant interest, but also we need to connect this question to, let's say, the question of audiovisuals and other products that we have been used to protecting. And let me be very, very clear. I'm not a big fan of Disney movies like more than some of you are. Maybe you are, but let me put it this way. There are some concerns about American culture being overswarmed in the EU. And I think that question is slightly irrelevant for two reasons. First of all, in the age of globalization, it's very, very difficult to talk about necessity in terms of protectionism against foreign cultures. And we need to bear in mind that there is a strong linkage between commercial freedom and political freedoms. You may not buy into the principle of modernization theory that one leads to another, but I'm 100% sure that if you start to enforce commercial restrictions, it will inevitably lead to political restrictions. I don't want any government to say what kind of culture is acceptable and not acceptable or in favor. There are the principle towards audiovisuals and how we want to encourage minorities and language and the cultural variety and access to culture needs to be modernized in the age of internet and globalization. It's a sheer simple fact. And the 60s model of protectionism, unfortunately, is unsustainable. And it's unfortunately inefficient because, simply put, the culture is accessible anywhere. And we have seen the part of the let's say the massive copyright violation that people accuse Europe of is simply because of the fact that these products are not available on the commercial market. Thank you very much.
Thank you. Very interesting points and context. Let's move to the next speaker, who will offer a more academic but very valuable perspective. Bert Hugenholtz, professor at the University of Amsterdam, professor of intellectual property law, and director of the Institute for Information Law at the University of Amsterdam, has published widely about intellectual property rights issues, as well as in relation to the internet, advising our Ministry of Justice, has been a consultant to WIPO, the European Commission, and several other national governments. We look forward to hearing from you. Thank you.
Thank you for inviting me to this panel. I was asked to briefly give you an overview of the main differences between IP protection in the United States and the European Union. But I have actually rephrased that question to the more general question that, of course, occupies us all. Why should we include an IP chapter in the forthcoming, if it ever forthcomes, free trade agreement between the US and the EU? Both the US and the EU, as already has been stated by previous speakers, of course, already provide for very high levels of protection of intellectual property, well exceeding the TRIPS minima. If you look at the FTAs concluded by the EU and by the US, you see a lot of TRIPS plus elements. So further elevating levels of IP is hardly an argument, and I think we already heard from Mr. Schlegelmilch that that is not the intention either of the European Commission. The ratcheting up argument that you normally hear in the context of the FTAs doesn't apply here. So how about the other argument, smoothing out the differences, harmonization? Is that a reason to include an IP chapter? Well, yes, differences between the US and the EU actually do exist. But as we shall see, as I will conclude already now, I think they themselves hardly justify an IP chapter by themselves. Let me give you a rough overview of these differences. Patents, already mentioned. In the patent field, the differences used to be quite substantial. The US had this first to invent structure, whereas the EU and most of the rest of the world actually adopted the first to file system of patenting. But the US has recently converted to the majority opinion, so that's hardly an argument. Another area of differences was, and perhaps is to a degree, subject matter. The US has been very liberal in protecting subject matter of the more elusive kind, like business models and software. But if you look at recent US court cases, particularly the Bilski case decided by the Supreme Court, the US now seems to be more in line, more restrictive with European standards. If you look at Europe, Europe actually excludes computer programs per se from patentability, but does allow, and in practice generously allows, hardware implemented software patenting. So the differences there aren't that big. In the field of GIs, of course, the most contentious area already touched upon by our first speaker, there are major differences. Even there, though, we should admit that the US and the EU are already bound by common standards in the TRIPS agreement. Modest standards, but they're there. Of course, the US does not, as we do in the European Union, provide for a system of registration, a sui generis protection of GIs that protects more strongly geographical indications than in the United States would be possible under the application of trademark law. Trademark law is the main source of protection in the United States. The US does protect against misleading uses, but not against uses as such. So there's a gap there. And of course, as we all know, the European Union has, in various forms in the past, been very actively pursuing higher standards. Most recently, in the context of the World Trade Organization, in the Doha round, the EU, yet again, to try to convince the rest of the world, particularly the United States, of its registration system. But as we also know, that those efforts were unsuccessful, at least in the Doha round. Given those recent failed attempts, I don't really see how this agreement could change the result. This appears to be an area where the US is not very willing to compromise. So I'm not so sure GI protection in itself would justify an IP chapter, but maybe I'm not seeing things here that are on the table somewhere. If we look at trademark law, there are differences there too. The US follows the use-based system, whereas the European Union has always based trademark protection on registration as such. So quite substantive law, the differences aren't that big. So I think we can quickly go over to the area where there are larger differences, and this is also the area where I feel most comfortable, copyright law. The United States officially grants copyright without formalities, but there are still formalities there, particularly in the internal US situations. There are statutory damages that are not available in Europe, and there's fair use, which we do not have here, not yet have here. In the European Union, we do have lots of moral rights, whereas the United States do not like them. We have neighboring rights, which technically do not exist in the US. We protect performers and broadcasters better than in the US. And we, of course, have the database right, which does not exist anywhere else outside, the EU and its sphere of influence. We also have stronger protection for technical protection measures. So there are some substantive differences there. Another more recent difference is exhaustion. In the European Union, copyright is exhausted regionally, whereas in the US, according to a recent decision by the Supreme Court, there's international exhaustion. So those are some quite substantive differences. Now, are these differences impediments to trade that would justify inclusion of an IP chapter in this free trade agreement? Most differences, I think, are relatively marginal. They may entail some transaction costs. They may raise transaction costs in trade between the EU and the US. You will sometimes have to consult a lawyer across the Atlantic to know what your rights are in the other country. On the other hand, the differences are well known, they are well documented, and so the transaction costs, I think, are limited there. Insofar as the differences are more than marginal, I seriously doubt whether there is enough willingness on either the EU or on the US side to actually compromise here. Is the US really going to introduce GI protection according to our standards? Are other differences that are deeply rooted in different national traditions easily traded off? I'm not so sure, actually. I have serious doubts there. And then there's another thing. We should never forget, of course, that both the US and the EU are bound by international treaties that, in a sense, bridge the gaps that do exist in terms of substantive law. We have the Patent Cooperation Treaty, we have the Berne Convention, all instruments geared towards facilitating international trade in intellectual property. So is there any evidence that the differences that do exist economically impede trade between the US and Europe? I've been looking for that evidence. I'm not an economist, but there is actually a study on that from a couple of years ago, 2009, commissioned by DG Trade on non-tariff measures in EU-US trade and investment, an economic analysis by Ecoris, a Dutch company. What do they conclude in this respect? I quote, "It is not clear how high the level of actionability of NTMs," oh, you really need to know your abbreviations here. NTMs means non-tariff measures, in the field of IPR really is. These NTMs have tended to be constant, and both the EU and the US have long understood their respective IP issues. In some, I'm not so convinced. On the other hand, I think there are some really good reasons not to include an IP chapter. For one, levels of protection are already really high. That's mentioned earlier. For another, including an IP chapter is asking for trouble. ACTA is not easily forgotten in the internet community, and we can say 100 or 1,000,000 times that this is something completely different, but I'm not so sure that the internet community will hear that. Moreover, aiming for a limited number of issues, which sounds like a prudent approach advocated by the European Commission, may easily lead to a large number of issues, and you already see that, particularly on the American side, the number of IP issues is already expanding. Finally, and I think this is the killer argument against including an IP chapter, including IP standards necessarily locks in these standards between the EU and the US. Even if these standards comply with what we are used to now, they will restrict us in the future if we want to reform. Now, that's not a theoretical argument. Reform is very much in the air today, both in the United States and in Europe, particularly in the field of copyright. There are discussions going on in the House in the US. There are discussions, look at recent statements by the US Register of Copyright. There are major discussions in the European Parliament about the scope and the extent of copyright protection. If we lock in these standards now, we will regret that. We cannot roll back easily. So that in itself, I think, is a good reason to be extremely cautious with including an IP chapter. Thank you.
Thank you very much. I'm sure we'll come back to that sort of dynamic between not changing EU fundamental law, lock-ins, is the system broken or not, what reforms are needed, etc. But I will not jump ahead to the discussion before introducing Joe McNamee. To those of you who haven't had a chance to meet him before, as the Executive Director of the European Digital Rights Group, which is an association of over 30 privacy and digital civil rights organizations from across Europe. Besides data protection issues, he's dealing with some other things related to the digital world and civil liberties in that context. So thank you for joining us.
Thank you very much. I'd like to strongly underline what Bert just said. It's extremely important. At a time when, particularly in the internet environment, we've followed the same approach for quite a while in both the EU and US. There is a growing recognition that there has to be a change. There's never a good time to lock yourself into anything, and this is the worst possible time. There was an event this morning which I couldn't attend because I was going to a data protection event, organized by an initiative called Friends of TTIP. I worry about the wisdom of anybody being a friend of a document that hasn't been written yet. But in the same way, I think it's not necessarily a good idea to be an enemy of a document that hasn't been written yet. Despite an interesting recent history, maybe we can give DG Trade some trust, and maybe we can also become friends of TTIP if the ACTA mistakes can be avoided. Bless you. The draft mandate, which was leaked by a US organization, refers to, in its preamble, to democracy, rule of law, and universal human rights. If we can stick to diligently respecting democracy, the rule of law, and universal human rights, we're not going to go too far wrong, and we're not going to go down the ACTA route. On the first page of the leaked draft mandate, there is a very convoluted sentence which ends with, or otherwise meeting legitimate regulatory objectives. In the US, there is a very, very strong drive in every area to self-regulation to privatization of policymaking. US experience and EU experience does not fill one with hope. The European Commission's approach to self-regulation is chaotic, to say the least. I commented to a director in a different DG this week that it is a remarkable failure of the Commission that it does not have a proper methodology for dealing with self-regulatory initiatives. And that Director General's response was, that's not an error, that is a policy decision. Similarly, the approach of the United States towards self-regulatory initiatives is not exactly something that would fill one with joy. I had an interesting, entertaining, actually quite fun meeting with Cameron Kerry a few months ago, before the data protection regulation was proposed by the Commission. And he was lobbying me for the need to have open flows of data across the Atlantic and how wonderful this would be. And I said, yeah, if you believe in this, and I don't doubt that you do, Section 104 of SOPA, American companies can take unilateral punitive actions against European companies. Not if they're breaking the law, not if they're perceived to be breaking the law, but if the company has a reasonable belief that they may be dedicated to the, quote, theft of US property. How do you match these two differing views, I said. I don't know, he replied. Similarly, one of the problems in ACTA was it was an effort not just to be an agreement among the parties, it was an effort to establish global norms. We'll arrange it among ourselves, and then once we've agreed, we've got a norm which we can then push out involving countries that weren't asked to be part of the discussion in the first place. The draft negotiating mandate refers to contributing to the development of global rules, and the Inter-Committee's draft resolution also refers to norm setting. Democracy also won't be served by occasional meetings, if you manage to get registered, but I'm sure we'll solve that problem in due course, with DG Trade, where in the ACTA discussions, the engagement between DG Trade and civil society, I sat in those meetings and it felt to me a little bit like I was trying to eat soup with chopsticks. I couldn't communicate. Nobody was listening. You also can't discuss, you can't have democracy unless you know what you're talking about. The even broad direction of the discussion of the negotiations were never discussed. Thankfully, we had lots of leaks. Transparency, or lack of transparency, will be very good for killing TTIP, if it comes to that, but it won't be good for facilitating democracy and ensuring a TTIP that is worth being a friend of. And finally, democracy won't be served by the inclusion of investor-state dispute settlement. The lack of such measures have never been identified, to my knowledge, as a barrier to trade, and the presence of such measures would be a barrier to democratic decision-making. So with those few points, I'll leave it at that.
Thank you. I promised to give the panelists a first opportunity to respond to each other if they want to. So let me just look around if there's any thoughts that need to be addressed. Yes? No? Okay, yeah, we'll go back to Mr. Schlegelmilch and then to Hosuk, and then maybe you two want to respond, and then I'll come to you. But maybe I can see a show of hands just to get a sense of how many questions there are to manage it within in the meantime. Okay, that's modest so far. All right, go ahead.
No, I don't want to monopolize the debate at all. I think there is just one or two small observations that I'd like to make. Obviously, this is going to be difficult, and some of you have said it's so difficult it's not worth it. But this is what I tried to say in the beginning. What we're trying to do here is really to not do any other FTA, but to really look for a game changer. Now, past experience is, of course, maybe not the happiest ones. With the US, we have lots of problems. GIs was mentioned. Other things have been mentioned. I didn't even hear the chlorine chicken thing come up. But if that's a reason not to do anything, we might as well close our shop. I mean, this is also an opportunity. Let's look at the opportunity we have here. If we find out it doesn't work, at least we can't be told we haven't been trying. That is maybe a little bit naive and optimistic, but I think if that's at least what I'm paid for, to try. To give it a try, especially if stakeholders come and tell me, look, I have a problem, and this is why we're not doing this top-down, saying we want a chapter and it has to have ABC. We're saying let's listen to what people who are in the business of doing the industry or doing the work and making the money, what they have to say. And we have a couple of requests that I tried to address, and there are more out there, I'm pretty sure. And it's our duty at least to have a realistic but ambitious look at these issues. I think this is the most important thing. The other point that I think I need to react on, the whole question of democracy and so on, transparency is really important. And we're not trying to have a soup that you can't get your spoon around with. We're trying to be as transparent as possible, and we're here to explain where we are in this negotiation. And that's the leitmotif, I think, what we are trying to do here. We have the best intentions to do this in a cooperative way. And as I said, and I will repeat again, this is not about intransparent, undemocratic, backdoor deals to the detriment of the internet community or anybody else. That's all I can say, and you'll have to prove me, or you have to sort of ask me 6 months down the road whether we can live up to that.
Thank you. And, well, what can I say? As much as I hate to admit, I actually agree with Rupert. It is difficult. And this is exactly why we need to do it. And if the largest economic link and the biggest strategic partnership in the world post-World War II is defined by chloride chicken, and if that's the most biggest issue we have at hand, I'm willing to resign right now from international trade and never talk about it again. I mentioned that priorities in IPs are different and in my view wrong, and I exemplify this by GIs and copyright. And to put it very, very narrowly, I don't think Yoko Ono's right to inherit John Lennon is more important than, it was Nokia who was invited today, was it? Well, or the other companies who may have European interests who were invited to speak today who couldn't show up. I think overall, in terms of industry and economy and the service industry, I think patents are more important. That does not necessarily mean that we can basically skip the IP chapter altogether because we have so little discrepancy between us. Because if we end in that argument, we can even say that actually no free trade agreement is worth doing because the tariffs are so damn low in Europe. And they still account for a significant boost in the GDP. And there's another example, which is if we give free pass to, let's say, United States or any other country, because they already signed on to WIPO treaties or because our systems are sufficiently similar, we are basically giving a free pass to all these countries who do not live up to those standards. And this may not even be IP. This could be a question of, let's say, labor rights, sustainability issues, or, let's say, product discrimination. So it's very difficult to say that we encounter this argument, I think, in many of the FTAs who are democracy. Why do we include the political preambles that are included in all free trade agreements? Well, simply because we need to ensure that these standards are maintained. They are not always aimed at the counterparts, but to the third countries. And we need to bear in mind that if we talk about TRIPS and WIPO, we haven't had, regardless what our politics are, if we want to have further the construction of the IP structure as such or whatever, we haven't had any significant movement in these organizations for a very, very long time. So the question comes down to, just because it's too difficult or just because there are too few similarities isn't actually a real good argument, actually quite the opposite in the context of international trade. These are not good arguments. Another thing I would like to add in terms of eating soup with chopsticks, because I was born in a culture where we eat soup with chopsticks every day of the week. And I'm happy to show how. But in that context, it's maybe worth to put that the biggest opposition to ACTA and other agreements, and also free trade agreements that I encountered, is probably the question of transparency. And there is not a single silver bullet to solve this problem, because international treaties, whether they are disarmament agreements or peace treaties, or we are talking about policing agreements on the judiciary cooperation or free trade agreements, they are negotiated between elected officials and their representatives in dodgy places like Brussels and Geneva, to be honest. But there is not a single answer how we can make these people accountable. But at least in Europe, I think the reform of the Lisbon Treaty has provided one step towards the right direction, which is the involvement of EP. This House has the possibility to ratify and has the right to be reasonably informed. And when they are not, the debate goes wrong. And we've seen that example, and I hope people like Rupert have learned from that experience, and also our counterparts like the United States, the USTR, has learned from that experience. So we will see a considerably different debate in that regard.
Very briefly, I applaud the optimism of the European Commission, and indeed that's what we're paying you for. I'm being paid perhaps to be more skeptical. And I really think you're asking for trouble. I do applaud the idea of a TTIP, by the way, but without the IP.
Just to clarify, I was trying to say that I'm giving you the benefit of the doubt that what happened previously doesn't have to happen again. I hope, I'm not paid to hope, but I will hope that the lessons have been learned. And if I can get in, I look forward to Friday's meeting.
All right, before we go to you, I just wanted to say two things about lessons from ACTA beyond the lessons on transparency, which this House of elected officials deeply cares about. And just to correct any possible misunderstandings, at this moment it's not elected officials on the European side that are negotiating trade agreements, but we are checking those who do and hope to do so in the most closely involved way to be able to represent citizens of our countries as well as we can. But an important lesson that we learned from ACTA is that it was not a dividing line that ran across the Atlantic. It was a differences of opinion between several actors in our own societies. Hosuk spoke of a Hollywood marriage, but perhaps this was a Silicon Valley affair. The anti-ACTA lobbying from the United States on our part here in the European Parliament was significant. So the challenges of a digital economy, of access to culture, access to knowledge, are not conflicts between the US and the EU per se, but are challenges that we need to meet. And in that sense, I do believe the system is partially broken, or at least it's outdated, because it has changed relatively to the world around us, or it has not changed sufficiently to meet the developments of internet. So I'm very interested to come back to how trade agreements do not change EU fundamental law, but how they could or could not create lock-ins, and how there would be enough room for reform. But I wanted to go around the room and collect 3 questions per round and give the panel an opportunity. It would be great if you could introduce yourself and keep it, brief so that others also have an opportunity. I know there's 2 questions here in the middle. I'll start here in the front. Please use your mic. Yeah.
I'm sorry. With this talk of transparency, does that mean that when the EU shows text proposals to the United States or the United States shows text proposals to the EU, so both parties actually have seen the negotiated proposals, that those will be made public? I know the United States has a system where they show about 600 people that work for big companies these things. They don't show the general public these things. They'll bring people in, they'll have them sign non-disclosure agreements, they'll brief us, they'll do all sorts of things short of allowing you to disclose for the broader public. And a lot of times these things are really complicated, and we would like to ask the opinion of people that are more knowledgeable than we are about various things, that are specialists in things, or how they think they may affect them, or what insights or suggestions they may have. In the United States, if somebody leaks one of those documents, they can go to jail. It's a lot of the transparency that took place under ACTA was because people risked their jobs and their careers, in some case even imprisonment, to release text, which is, I think, a bad way to think about transparency. So what I don't understand is if both the United States and the EU both have access to the text, what is the and these 600 corporate advisors have access to the text. Who exactly is served by the secrecy? And then on the substantive things, would it be possible, instead of the other kinds of agreements are just about sort of increasing the rights of right owners, to imagine an area where even the United States and European, even though they really are very much emphasized in that way, can recognize that there's some areas where you could have, there's trade-related issues where you could have exceptions. There's a diplomatic conference for blind people in June that create cross-border sharing of works for people that are blind and have other disabilities. There's been a lot of work in the Parliament on that issue. And it would be crazy not to think about how you're going to implement that between Europe and the United States, because they're the 2 biggest entities that basically have these works. And then the Justice Department and the Patent and Trademark Office have recently issued a position paper saying that they should rarely enforce injunctions on standards relevant patents. And I think this is a reaction to the mess that's taken place in mobile computing and places like that. But that seems to me is, I don't know if it is sort of a norm-setting issue, but it is certainly a trade issue because these goods really move in trade. And I think that it's an area where we had hoped there'd been discussion on it. And another one is on access to publicly funded research. The United States provides safeguards to the Bayh-Dole Act that benefit, at least in theory, the United States of having certain public interest access to the things. I'm assuming that European governments do the same kind of thing. And in some cases, the U.S. provides public access to the research papers themselves. But would it be possible for the European Union and the United States to sort of grant each other reciprocal rights of public interest safeguards in government-funded research that could place both in Europe and the United States? So that if there's an abuse of a patent right, say, for example, on the BRACP patent, which was a breast cancer patent, could you extend the Europeans the right to march in, just like, and vice versa? I'll wind up here. Thank you.
Thank you.
I'm sorry I didn't identify myself, but I'm Jamie Love. I work for a group called KAI, Knowledge Ecology International.
I'm Ante Wessels. I'm involved with the Foundation for Free Information Infrastructure. Mr. Lee Makiyama said that free trade agreements should not be read as civil law. And I wonder in how far investment state dispute resolution is a game changer with regards to that, because the arbitrators are civil law lawyers and they read it like civil law. So it really changes the effect international agreements have. So I would have a question there.
Yes, hello. My name is Elizabeth Shostad. I'm a film director and the chief executive of FERA, the Federation of European Film Directors. I had a question for Mr. Lee Makiyama. You said in passing that you dismissed the opposition to including audiovisual services as a 1960s protectionism. And I wanted to challenge your view on this, because if you look to see what happened to the South Korean film industry when they had to relinquish some of their quotas on cinema screenings for their local and very strong cinema, in their free trade agreement with the US, that was to the detriment of the South Korean film industry. So with now a petition of 5,000 strong signatures from the European filmmaking community, you can surely see that we have also other examples that show that that's not just an anachronism today. So if you could please elaborate a little bit on that. Thank you.
Thank you for those questions. Who could I give the floor first? I think most questions were to this side of the panel. Bert also wants to answer. Do you want to start, or no? Go ahead.
Thank you. Well, I mean, the first question is the one on transparency, and I think you know very well the system in the US, because you cited from the confidentiality requirements that are in place there. And we have been not finding yet the full answer to how we're going to deal with this on our side, but what I can say is that we have well-established procedures with the Parliament. Anything that goes out by way of a proposal for negotiations is shared with the Parliament. We don't make all these documents public, because the idea that every negotiating document immediately is public will not make it easier to negotiate, but make it more difficult. But those who are responsible and have to sign off to the agreement, which is for us the Council and the Parliament as the representatives, and that can include, I think, a quite wide array of people, will have first-hand information. On top of this, we will do what we can to make sure that there are no surprises. We're not intending to copy the American system, at least that's as far as we have right now. The negotiations haven't started yet, but we don't think this is necessarily fit for European purposes to copy that system at this stage, at least. Then I will just say one word, because it's tempting to talk about investment as well. It's a huge issue. It's not the debate right now that we have. I just want to say we are aware of the concerns, and we are trying to improve a situation where an arbitrary panel of 3 people interprets treaties not even every time in a coherent way. We are aware of the problem with jurisprudence in that respect, and we will address it in one way or the other. And I'll shut my mouth on audiovisual. There's a huge debate going on this, including of what or what not should be in. The Commission has taken a clear view that a complete exclusion doesn't work, but we will not go after quotas. I mean, this is something we have said publicly in many instances, so I think we're at least on the safe side of the argument in this discussion.
Very quickly, on the question of investor-state dispute. And I understand the question that why can we refer to a third court? Why isn't the national court good enough, etc., etc.? Let me reflect a little bit. We fought very hard to have an investor-state dispute in the auspices of World Bank under ICID in China. Why? We can't basically trust that the Chinese court would be fair. And there are many instances, not blatant political control of the courts in certain countries, but also simply because national law, in terms of evaluating evidence and etc., makes it very difficult to win against the state of the host country if you're an investor. So this is the reason why this has become a prominent feature in our BIT, bilateral investment treaties. And also, it makes it also very difficult to say that we want them when it benefits to us, but we don't want them when other people may sue us. It's like to say, we want to export, we don't want to import anything. Either you're in favor of a principle or you're not. It's simple as that. And if you think that we are better off by saying, no, we don't trust a third-party court, then I think we need to think twice about whether this is the most efficient way to, let's say, raise the standard for investment protection around the world for European investments. Second, about screen quotas. This has been included since the first days of GATT, and there is there are one of the very few exclusions in the General Agreement on Trade and Tariff is on screen quotas, and it was actually an European protectionist interest. And let me tell you like this. I mean, I understand the fact that some people don't like American movies, and I don't. But I don't want to have a government policy dictating what kind of numbers we should have on movies as well as other products. This is the core principle of liberty, commercial freedom. And if you want to promote diversity, you are actually spot on and pointing at Korea. I don't like much of the Korean pop culture that comes out either. I think some of them are actually abominations, but still, thanks to liberalization and thanks to the fact that they changed from the quota system towards a model that we are more familiar with, which is direct support towards the creators, instead of protectionism, rather, let's say, subsidies and more offensive interests, they have actually been able to promote Korean culture and pop culture to a level where they can talk of it as a soft power. So I'm all in favor of your members, but I don't think the protectionism will help them. I think this actually helped them to basically become marginalized, and I think it's directly against their interest. This is the reason why, including things like market access in, let's say, video on demand and other issues, will be highly beneficial for European culture rather than vice versa.
A quick reply to Jamie Love's second question. He suggested to perhaps include some limitations and exceptions in an IP chapter in a TTIP. I think that's an interesting idea if you include minimum standards for IP, then it makes a lot of sense to also include ceilings. Limitations and exceptions are equally relevant to trade as are the rights. It has always surprised me that the standard FTA that we've become used to, both from the US and the EU, only talks about rights and never about limitations. The recent exception is the TPP, which does include some mention of limitations and exceptions. So if we do this with an IP chapter, I think it makes a lot of sense to include ceilings, limitations and exceptions.
Can I try to re-ask Jimmy's question on transparency, because I'm not quite sure what the Commission wants. In a perfect world, what would you propose for transparency in this context, if I could?
And maybe I can add, while you think about the perfect world. In previous agreements, there also have been confidentiality agreements signed. Has that already happened between the EU and the US at this point? Will you foresee it, and how does that play into the transparency question? Which, as far as I understand, because we also raise it as members when we visit the United States to talk about trade agreements, is something that is discussed by the US trade representative and the US government as well. So it sounds like there's an appreciation for the need and the demands from both societies, but the question is how to fill it in and to get support and actual discussions.
Well, I think it's a valid question. As I said, it is difficult. Maybe moving away, and I'll explain why it's difficult. If you talk about some of the issues which are important to many people, and maybe let's take the chicken, the chlorinated chicken thing, where we also are facing a lot of questions how we're going to let some of these products in. Lactic acid was an issue where we had to accept some of the processes which are US-based and not necessarily our own way to do things. Huh? Now, if you want to discuss these sort of things and you made this as a public announcement, I mean, of course, those who don't like it will immediately go up and say this is a very bad thing before you even had a chance to explain what you're trying to do, what safeguards are there, and so on. And your negotiating partner will accuse you of negotiating through the press and negotiating through public opinion and so on. Our job is to sort of sort these issues out with in mind what is the public good, but we don't do this independently. What I said, we will have a very close contact with the elected, not the elected negotiators, but the elected people who are supervising us, because we're not independent, we're accountable, and we know that. And that is why we are trying to find a system, and we have a system in place where we share the documents with the parliament in various degrees of the group leaders or the whole parliament, depending, and so on. We have not signed an agreement with the US on anything. We have explained this to the US, what we want to do, and I don't think that will change our practice as a result of this agreement. We have an established practice in this respect. I think this is the way I would like to explain it. And it's delicate, again, because there are offensive and defensive interests, and we have to balance out the opinions and make sure that the final product meets the expectations of everyone. And in the process, there will be a constant oversight of those who are elected and take the responsibility politically, be it on the council, be it on the parliament side.
Just a brief comment, because there has been some nitwitting about my choice of words. When I talk about elected people, then we are talking about the council. We have to bear in mind they are part of this equation too. So, of course, European Parliament introduced a very important dynamic in terms of public accountability and transparency. And of course, they need to be involved. People like you, Marietje Schaake, needs to be involved from the day one. And I think that's a very important, but not necessarily first step. But we need to also bear in mind that the mandate actually comes from elected national governments, which are the member states. And in terms of transparency, there is a lot of focus on the civil society versus Commission interaction. That's one part of the equation. The national government cannot escape their responsibilities either. So I would like to bear in mind that they are informed from day one, because they set the mandate of what non-elected officials, like Rupert, are supposed to negotiate. And this is something that civil society very often comfortably forget.
Thank you. I'm going to look around, give the floor to Christian Engström first, my colleague, member of European Parliament from Sweden, the Pirate Party. Are there other questions? Let's see if there's people who haven't had a chance yet. Yeah. All right. I'll come to you in a second. Christian.
Sorry, continuing with this transparency thing. I mean, I fully agree with what the panel has been saying. It's going to be very, very difficult indeed to convince the internet community that an IP chapter isn't just an ACTA zombie. If nobody is able to read it, I mean, I simply can't see how you would be successful in that. And I don't think leaks are sufficient, to be honest. So I would, would urge you to revisit the transparency thing again. And what you said, the Americans will blame you for negotiating through the press. Please feel free. I'm sure that both Marietje and me and lots of other members of the European Parliament are more than happy to take the blame for any transparency. I mean, that is what we were asking for in the ACTA context. So I mean, tell them it's us that's actually true, and yeah, so that's fine. And the second point is you said that various activist groups who are interested in one particular issue, like chloride chickens or whatever, would react very quickly. Okay, I'll concede. I mean, take a couple of days. I mean, wait for a week after the negotiation run, so that you have the time to prepare press statements, etc., and release it then. I mean, that would be an incredible improvement over not releasing the text at all. So just submitting these as a suggestion, because I do agree with everybody who said if this agreement is negotiated in secret and contains an IP chapter, I really honestly can't see how you could convince either me or the rest of the internet community that it's not an ACTA zombie.
Yes, thank you. Elizabeth Shosted from the film.
I'm sorry, I wanted to give the floor to a gentleman right behind you who hasn't had a chance yet. I'm sorry, it's the same direction with the laptop, but for lack of better identification.
Yes, thank you. My name is Ulf Pettersson, and I work as a policy advisor for Amelia Andersdotter. You asked about the ideal, transparent, and democratic way of doing this. And my idea then would just to be, why not do the negotiation on the text in open web platforms so that everybody can see it and contribute to it? You don't have to release all positions before this, of course. You can agree among yourselves. A step somewhat behind this, you will just publish everything in a wiki-like platform and everybody can contribute. What are you afraid of? Public input?
Any other questions? Otherwise, I'll return to the lady from the filmmakers industry.
Yes, thank you. Sorry, I'll be brief, but I just wanted to clarify that I wasn't advocating green quotas. I was using it as an example of where cultural policy is given away in a free trade agreement. And I really would like to challenge again Mr. Schlegelmilch why exactly it is that the Commission doesn't believe in full exclusion of audiovisual services, given that alongside weapons export, Hollywood products is the biggest export from the US. It would be hard to imagine that they wouldn't want to obtain something from the EU in the context of these negotiations. And it does make us feel like we're being collateral in this context. So you can understand, surely, our concern. Thank you.
Can I give the floor to you?
No, thank you. I'm grateful for that feedback. And I would like to, if I can, dispel this fear, maybe starting with the last issue, even if it's only remotely maybe linked to the IP agenda. We're not trying to create collateral or anything. I think what we are trying to do is to be true to the idea that this is comprehensive and no things are excluded from the beginning, because the negotiations, if we started on that basis, and that has nothing to do with the fears that you have at this stage, if this sector is excluded, there will be other exclusions. There will be maybe financial services, GIs, or whatever. It's just not a good way to start, to say, this is something I do not want to talk about. I mean, there will be sensitivities on both sides. I mean, agriculture is a huge sensitivity for Europe. We don't exclude it. I mean, we have people who are demonstrating just as adamantly or demanding things just as adamantly as we see now in the press on the cultural industries. What I'm trying to say is we're not going to ignore the sensitivities at all. But the fact is that if you start excluding things, you're not going to get this comprehensive, game-changing approach. And we've been trying to be very clear that the existing EU legislation, as some of you have said on other issues here, IP, is not at stake. We will not touch the subsidies, the media too, the quota system under the Audiovisual Services Directive and so on. That is not the point. The question is to be able to say, we'll listen, what if there are major requests, which frankly I haven't seen yet from the US on some of these issues, we will be able to talk to them and we will be able to consult and see what is it that they might want to raise here. But we've been telling in public, and we've been saying in public that we're not going to change our system here in the EU. The fact of the matter is that would be a disaster, not only for you, but it would also, I think, be a disaster for our credibility. So what is in our existing legislation is not at stake at this stage. I have to be very clear. But there is a difference between having that on the table, having everything on the table, not specifically focusing on one particular sector, or starting with sectoral exclusion, which will very soon lead us into issues like air transport, maritime transport, which are very difficult for the US, and other issues. I mean, I just quote a few examples. So it's more the question of getting it right in the beginning. And then on the question of transparency, why don't we put everything immediately on the web? Maybe that would be, as a citizen, would be my preference as well, because I think the question of accountability goes down to each and all of us. But I think the experience is, and if you've ever done a private negotiation yourself, there are things that have to be measured. The information flow has to be measured, because lots of people have an interest. Not all are well-meaning, I think, in your own experience. Some people just don't want this to happen. And that is one of the reasons why I think, as my colleague here has said, we have a mandate to make this thing happen. We will be extremely transparent with those who mandate us and who are overseeing us, and we will give the maximum of information to anybody else out there. But having it in public, I think, would be that we negotiate with our own public and not necessarily with our negotiating partner.
Yeah, was that?
That's
Okay.
it, yeah.
Thanks. No, I just wanted to take the opportunity to add something to the idea of input and using the web. As an MEP who has to hold the Commission accountable and who's doing so with great pleasure and ambition, I've tried to facilitate access to information about this agreement through my site, but I also wanted to create an online platform that asks for input and is kind of like an assembly place online for, you know, input or lobby materials or opinions or criticism that anyone can access. Because I think what we're experiencing today as well, the scope of this treaty will be very wide. And it will be a matter of different issues, some very specific, relating back to a bigger picture, to macroeconomic questions. And to keep track is not an easy manner, so we have to facilitate that. So I will announce it as soon as I'm ready in a, you know, sort of public open forum where anyone, and this is an invitation to you and your organizations and your businesses and you as private individuals, could also upload materials that you believe are important for others to know, and then we can have a discussion around there. But I also think it's good to use fora like this to really come forward with your advice and to use the platforms that exist in the most constructive way. But we'll return to the panel now. Did you want to answer, or the other side of the panel? No? Joe, yeah?
Briefly on the transparency point again. As Jamie tweeted, the WIPO discussions are, and documents are published and made available very quickly. Everything's online. Part of the problem of this House is that people aren't interested enough in the discussions that are happening. The idea that you'll be overwhelmed by interest for the value of the European Union, for the European Union's communication with its citizens, sounds like a wonderful thing. And to remake the point again, if we don't like what's in TTIP, as the leaks come out, in the same way as transparency, or lack thereof, was probably the best tool to kill ACTA, the lack of transparency will serve the same purpose again. I seem to be encouraging you to do what's in your own best interest. I don't see the value of non-transparency from your perspective.
All right, let me go around the room once more for any possible questions. Yes, go ahead.
Jens Jeppes and I represent the Center for Democracy and Technology, a public policy organization focusing on technology policies with an impact on citizens' rights. So just sort of coming back to the topic, we've been going far and wide, but I think we'll be lining up with the optimists for now, at least. I think in the comments that we are putting into this process now, we are urging restraint and caution in such politically charged areas as IP. And I hear from the Commission representative there's a sensitivity to that position. Equally on transparency, I think we'll be happy to be on your mailing list. We'll be happy to participate in Marietje's consultations and any other avenues that we can use for influencing these discussions. And I think you can take it as for granted that, as Joe says, that lack of transparency will be the surest way to derail the initiative. So, thank you.
All right, well, if those were all the questions, I'm really surprised. In fact, good, there's one.
Hi. I'm Reagan McDonald from Access. Access is an international NGO that protects digital rights of users around the world. I actually have a question for Mr. Schlegelmilch from DG Trade. I know you've been slightly bombarded, but I have another one for you. You mentioned in your opening remarks that if there was an IPR chapter included, that there wouldn't be any enforcement, but there would be cooperation. So the first question is, can we hold you to that? And then the second question would be, what exactly do you mean by cooperation? One of the most problematic issues of ACTA was the inclusion of cooperative measures with states and the business community. And specifically for copyright and in the online environment, this is an incredibly dangerous thing for human rights, because it, among several things, would encourage private companies to take down content, to filter, and to censor citizens arbitrarily. So if you could clarify that, that would be great.
Okay. No more questions, because this will be the last round. Okay, go ahead.
Yes, I think, again, certainly you can hold us to that. I think, I'll be very honest, I don't really know what exactly we're going to do, because this negotiation hasn't even started. What we have done is what I said. We have identified the question of, can we cooperate better in making sure that we address this joint problem. Counterfeiting, irrespective of ACTA, counterfeiting is a major problem. It's not going to go away. It's actually worse than it was every year. So what is it we can do to improve the cooperation, which, by the way, is already happening? As I said, we are meeting, just to give you an example, this is not a secret, we are very transparent, IP officials in Beijing or IP officials in Buenos Aires or in wherever there might be a little problem. They meet, they talk, they look at what they're doing, whether they're efficient, what can they do to train customs, what can they do to help identification. It's not on designs. It's very difficult actually to stop a design at the border. It never happens because nobody knows what a design actually is. This sort of thing is what we're talking about. What I'm trying to disseminate is the idea that we're going to have sort of ACTA-like provisions which paraphrase what we are doing, the level of enforcement. We will do this and that, and bind ourselves to it in a way which makes everybody so nervous. That's not the point. That's not what we're trying to do. And you can hold me to that. I'll be very clear on that. I'd like to add something on the transparency point. Maybe also for good of all of you to look at our regulation for access to documents. We actually have an EU regulation endorsed by the Parliament, and I think not questioned by anyone. That balance is reflected there. The moment where we also have a partner, we have partners who actually also tell us, we don't want our proposal necessarily to be shared with all of the world. We have a sort of international relations duty to respect that. That's also part of the international sort of relations argument, that not everything is immediately public. That has been, I think, established practice. It's especially necessary or especially applied in negotiations. And sometimes when we get requests for access to documents, and some of you are in that field very active, they write to us, we go and say, we cannot really tell you what the position of the other country was, because it's, they don't want us to do this, and they're very cross with us if we do it. And then we sometimes even take this further, and there has been a court case lately on this. I think it's just important to realize that we're not necessarily against all of this, but there are limits to what we can do if we want to be effective in everybody's interest.
I just want to respond to the question to the democracy issue and trade agreements, because I have on several occasions like this heard this argument so many times that free trade agreements are highly undemocratic. Transparency is one part of the issue. The other thing, that the result of them are somehow undemocratic. I just want to address that question, because I think it's a double-edged sword, if not outright intellectual laziness, to equate basically free trade agreement contains or may not contain provisions on IP, and that's by default bad. Anything that strengthens the ownership of IP must be bad. First of all, none of the FTA so far has made any substantial change or any change whatsoever on IP legislation in the EU. Second, we need to bear in mind that, for instance, if you talk about real human rights issues, like, let's say, inclusiveness, but also free expression on the internet. We have very little results so far in that area. And the only thing that actually worked against authoritarian countries is actually WTO agreements. And thanks to the commercial freedoms that we actually established in the WTO rules, in the GATS, we have actually managed to, very little, but at least move some of the filtering and blocking of websites towards the right direction. And I'm thinking of the biggest authoritarian country in the world. And it was not thanks to the Human Rights Council, it was not thanks to bilateral consultation, but it was thanks to the fact that this country actually understands the value of commercial liberty. And from that route, we managed to basically address online protectionism, which was disguised as political censorship. And I would say that the progress is far from good enough from our standards, from Europe, measured against European values, but this is the only thing that worked so far. So I would even go as far as saying, if you don't see the link between commercial restriction and basically discriminatory clauses based on nationality in provision of services, provision of products, or ownership of IP, whether you think the actual de facto IP instrument itself is good or bad, I'm talking about whether you are allowed to discriminate based on the fact that you're European, Japanese, Chinese, Korean, or American, you are de facto in favor of authoritarianism. And in that context, we need to look at the free trade agreement as a liberalizing tool and modernizing tool.
What the European Union and the United States are doing on an international level regarding filtering and blocking of internet is not getting rid of it. It's changing the nature so that it goes from being a state activity, which is difficult from a constitutional perspective in both the EU and the US, to being a private activity that is encouraged by the state, but not imposed by the state. In the space of a short number of months last year, you had a situation where Turkey was condemned by the European Court of Human Rights for its internet blocking law. And you had the EU and US set up an initiative which included a proposal and support for voluntary upload filtering, to which Turkey was invited to join, and where they did join, and where Commissioner Malmström said that Russia was invited to join. You have voluntary blocking in Europe. You have proposals like SOPA in the US, which go far beyond anything that any totalitarian regime has proposed, in wholesale liability exceptions for internet intermediaries to take punitive actions against foreign governments, against foreign online activity. You have companies like Google who are currently imposing US DMCA obligations in Europe, where your website will be delisted by Google if the US DMCA procedure is followed. So I'm sorry, but the analysis that you just gave is simply, factually, and very unfortunately, not true.
We're almost at the end of this debate. I think it's a good time to reiterate a very old-fashioned argument, but sometimes old-fashioned arguments are the best. Intellectual property is not primarily a trade issue. It has trade ramifications, but the whole idea of delegating IP legislation to trade negotiators, as it has, and this argument we remember from the early days of TRIPS and even before, is I think, highly debatable. there are very serious public interest issues at stake in IP legislation and also in international IP legislation, a fortiori, that are well outside the context of trade, even defined in its broadest dimensions. One example, most FTAs that we've been seeing now extend terms of copyright protection to life plus 70, which is now the European and the US standard, and increasingly elsewhere in the world. These term extensions have immediate ramifications for access to our cultural heritage. That has nothing to do with trade. I think we've been talking a lot about transparency, and I think rightly so. The ACTA fiasco is directly linked to a lack of transparency, which is, to a degree, I'm afraid, inherent to trade negotiations. But the ACTA fiasco is also a symptom of something deeper, I think, an intuitive appreciation that a lot of IP issues are not about trade, but about other things, possibly more important things. So that in itself, I think, would be another argument to seriously consider including IP in this new treaty. Having said that, again, I have the tendency of Joe to sit on the stool of Mr. Schlegelmilch. It would make your life a lot easier if you just leave it out.
Okay, I just wanted to thank everyone very much for their contribution, especially the panel. I don't want to repeat everything that has been said, but a few key issues that are important, that were important this afternoon, are to prevent policy laundering, to confirm again that fundamental EU law will not be changed through TTIP as such. There are still a number of questions that are out there, lessons learned really from SOPA and ACTA, which with public pressure did not become law, which is important to keep in mind. And I think it also shows how strong public opinion is shifting, and you know, that some may, if you look at how the balance turns out, you know, may wish to be able to change some of the laws and provisions that are not beneficial from their point of view through trade agreements, but that is not going to work. In any case, there's a lot of work and many more discussions that lie ahead of us, in which I hope you will participate. I think one of the key differences between plans like ACTA and SOPA and this Transatlantic Trade and Investment Partnership is the scope, where ACTA and SOPA and PIPA and other such proposals had a relatively narrow scope, too wide in the eyes of some perhaps, but relatively specific. This Transatlantic Trade and Investment Partnership will have a much, much, much wider scope. And so that also means that many different issues, sensitive as they may be, will feed into the question of whether, by and large, this is a good treaty, this will be a good treaty, or by and large, there is a lot of criticism. And so I would also encourage you and really invite you to look at the substance and see how that can be as good as it can be for the Europeans, for fundamental rights and principles that we stand for. Because I think that the dynamic around TTIP will be fundamentally different from that around ACTA and SOPA, and what may have worked with massive no votes before, with lots of emails on a specific issue, on one vote with a narrow scope, will be a different dynamic this time around. And so I will promise you here that whatever is in my capacity as a member of this parliament, as a member of the Trade Committee, as a spokesperson for the Alliance of Liberals and Democrats on the Transatlantic Trade and Investment Partnership, I'll do what I can to make information available, to inform you and to bring your input to colleagues and into this process when we're talking to the Commission, the Council, and other stakeholders. I'm also, you know, on the side of optimism of what it is we can accomplish in terms of economic development and jobs, but that's not to say that there will be very sticky issues, and IP is one of those issues that is already difficult within the EU that I believe needs to be reformed to meet the day an age that we live in, and you know, to be more relevant for generations to come. But you know, whether we like it or not, TTIP will probably not solve those problems all at once. So we still have a lot of work to do there too. That's for another discussion. I want to thank you again, and specifically the panel, Joe McNamee of EDRI, Professor Hugenholtz from IVIR, Hosuk Makiyama from ESIB, and Rupert for the European Commission. Thank you so much.